The matter before the court is State of Maine versus Michael Smith. This is Oxford 23113. Counsel, we are being streamed live on the web, both audio and visual. So what I would ask is that you introduce yourselves by saying your names for the record, and if you'd go to the podium to do so that the camera can capture you for the appellant.
Good morning, Daniel Feldman on behalf of the appellant, Michael Smith.
Good morning, everybody. I'm Richard Beauchesne. I'm an assistant district attorney for Oxford County, and I'm arguing on behalf of the appellee today, the state of Maine.
Thank you, Mr. Beauchesne. For a minute there, I thought you forgot your name.
It's been a long time.
And Mr. Feldman, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court. Imagine you're planning a vacation and you decide to take a cruise up to Bar Harbor on a luxury cruise line. You plan to see Mount Acadia rising from the mist, get off, explore the town, and the kicker is that advertised as entertainment on the boat is a world-famous magician. Now, when you get on your cruise and you get there, for some reason, the ship can't dock in Bar Harbor. So you park, it drops anchor off of Mount Desert Island, and sure, you can see Mount Acadia, and you can see it rise from the mist, but you never get off. You never get to explore the town, and you don't get to go to the national park. And to make matters more confusing, the world-famous magician does in fact perform, but instead of the wonderful illusions for which she's well known, instead she comes out on stage with a guitar and sings you folk songs. As a metaphor, that's what this case is about. My argument today is in 4 parts: prejudicial joinder before the trial and as applied after the trial, expert testimony, decision before the trial and after the trial. What we have is a decision made by the lower court, and I'm going to ask your honors, if you have any questions, to look at the submissions in the appendix from trial counsel asking for separation from joinder, arguing the very problems that came to pass here. The court below told him and told you that in the court's view, the alleged joint assault of EC and KS is not a crime, wrong, or other act within the meaning of 404B, but rather is evidence intrinsic to the charged conduct involving each alleged victim. It's not 404B. The court made no 404B determination. And so because it turns out that evidence tying those 2 cases together, that linchpin, was removed at trial, and I've gone over some of this in my brief, and I'll be happy to answer specific questions about it, that analysis turned out to be wrong. Because that analysis was wrong, so too was the 403 argument between prejudicial and probative, because the probative value of something that was supposed to be an intrinsic part of the case, something that the state was seeking to prove, turned out not to be what the state was pursuing at all. Only came up in asides, not as part of the case in chief. And so the prejudicial value went down necessarily, the probative value went down, the prejudicial effect necessarily went up. As this case was determined before trial, the objection was put on the record, this case is before you on those decisions alone. But I think what you've seen, much like that cruise to Bar Harbor, didn't turn out, the vacation didn't turn out the way it was supposed to be. This trial, what was promised by the state, never came to pass. And so based on those analysis before and after, we've got a real problem of unfairness to the defendant.
But your trip was planned in a certain way based upon certain expectations. So the planning was perfectly appropriate. It may not have turned out the way it was, as in this case, but here we're looking at the planning of the trip. So the judge looks at, okay, what's going to happen here? You've got intertwining witnesses, you got intertwining exhibits. The plan going forward is like this. The plan isn't flawed, even if it didn't work out, didn't get to see the magician.
Well, I think that that's correct on a certain level, Justice Meade, but let me explain to you, at the end of the day, the trial is what the trial was, regardless of what was promised up front. At what point when you have that trip do you want your money back? At what point do you say it was unfair that I didn't get to do those things? The quintessential question this court has asked in many cases on criminal law as we noticed in State versus White in 2020, is not what the subjective intent was, not whether the prosecutor had done something purposefully to make the trial unfair, but what was the end result of that. And in this case, the fact that they never once asked EC or KS about this alleged mutual incident made it unfair, because that's what was promised and not delivered. Now, when it comes to the expert testimony, we have almost the exact same problem. We had a voir dire on the beginning of-
Counsel, before you go there, can we
Yes,
just
Judge.
take another closer look at the joinder issue? The other basis that the trial judge relied on for her ruling was the notion that this was a common scheme or plan.
Right.
And she detailed pretty explicitly what the basis for that was. In other words, it was two children, roughly the same age, roughly the same time period, same location. So putting aside and even accepting for a moment your characterization of the testimony, isn't that sufficient enough to permit for the court to base its discretionary call on joinder?
Well, so let me break it down to before the trial, we never had a 404 analysis in the ruling. Judge skipped over that based on assertions apparently made by the state. So when we got to trial, it's on page 33 of the appendix, Your Honor, and I read it at the beginning of my argument. In the court's view, the alleged joint assault is not crime, wrong, or other act within the meaning of 404. It's part of the state's case in chief. The state never once asked EC or KS about this incident. EC volunteered some information in a very vague sense, and the state never followed up, never got time, place, location, anything about that into the record. It was just an assertion. It's in one of my briefs. I think it's in my reply brief.
But doesn't it go further than the joint assault? I mean, and I think that was here, but in this particular case, this wouldn't necessarily be true in all cases where siblings were both assaulted. EC witnessed, aside from a joint assault, she witnessed what happened, at least in one instance, to her sister, and the sister did not report it until EC did. She makes the report to EC. In other words, that the testimony is intertwined, that EC's testimony about what happened to her would be admissible at Kay's trial anyway, because it goes to why and when Kay reported and the like. I mean, this is different than a lot of cases and goes much beyond, and isn't that what makes the joinder okay here?
Well, with due respect, Your Honor, you're making a determination that wasn't made below, so I can't answer that question specifically in this case. If, in fact, we had had separate trials, I think that it's very likely that the trial judge would let in EC's testimony, but for limited purposes and under certain circumstances. She presumably would testify as a witness to a certain thing that happened, and only to that thing. And so
Wouldn't
we
Kay
would've-
also be testifying to the fact that she was aware of what happened to her sister and that had to do with why she reported to her sister and the like?
I mean, we would have done that analysis. We certainly would have gone through that, and we would have had to balance 403 and 404 in each case. But we didn't factually in each case, because what was promised was never delivered. What was promised was the state was going to bring, as part of its case in chief, at least one incident and presumably prove with some specificity, right, beyond a reasonable doubt, time, place, what happened, all of that. We never got to that. Now, what that did also, Your Honors, was put the defense to a disadvantage. The defense had no way of separating the two cases once we got to where the promised linchpin was pulled out, right? We had this case. As the chief has pointed out, we might have done an analysis on each case. As it turns out, what KS told in trial on defense question was, well, she told me that she had witnessed something. So that would have presumably been hearsay in EC's case, but as the chief points out, maybe EC would have been allowed to testify in a KS case, but we don't know how that balancing would have gone, and we hadn't had a chance to go through that and look at that. And I think that that creates a fundamental unfairness that calls into question whether, in fact, the trial was fair to the defendant. He was promised that the trial would go a certain way, and it didn't. On top of that, we have the problem of the expert witness. Bear in mind, Your Honors, that we had a one-day trial with the two witnesses, and the jury was told, you
Well,
need to
can
come
I
back.
stop you on the expert witness issue? There were no objections to any of the individual questions, correct?
That's correct.
So your, the motion below and your appeal here is premised on the idea that this person could not testify at all. Is that right?
Sorry, which person?
That Harvey Brown could not testify at all?
So again, my argument's in two parts. She was not the appropriate expert witness, as she did not have the training to provide that information to the jury. She's a master of social work, and she was testifying about things that were outside of her expertise. However, and I pointed this out in my brief, she didn't actually even testify about the things that she said she would testify about. The first day of the trial, before the jury came in, there was a voir dire, went on for however long. She explained what she was going to do. At the trial, however, when asked specifically, what does the research show? She said, let me tell you how I think about it, that a child's brain's not like an adult. This is in my brief. And
But the fact that she doesn't testify to everything that perhaps she could have testified to doesn't change the analysis about whether she could testify.
Well, and Your Honor, I think that this is a
And no questions were objected, nor was there any follow-up. I mean, the cross-examination is there for a purpose.
Yeah, and cross-examination, that was your opportunity.
Right.
What you're raising issues of weight. Now, if you want to talk about, the preliminary discretionary call that the judge had to make under Rule 702, experience or education is only one of several in that series of potential bases to be qualified.
And that's right, Justice.
And this witness had she was a licensed clinical social worker, and she testified that she was extremely familiar with the research, kept up to date on the research, and had knowledge of the area. And so she did meet, in the trial judge's estimation, the threshold barrier for qualification.
Well, and let me address the sort of two concerns put together is, before the trial, I mean, we know for a fact this court has said that delayed disclosure is a legitimate topic, scientifically valid. That's fine. We have no problem with that. Is this the right person to talk about it? The judge made a decision. I think it was wrong. I think it's before this court for review. But as it turns out, that's not what ended up happening at the trial anyway. So what we've got is two decisions before the trial, which presumably, you're right, it's a judge's discretion. I don't have much to argue about. But as applied, at the end of the day, when the trial was all said and done, none of those things came to pass.
Did you
And that
object? Did
created
you
a
make objection?
fundamental
Did you
unfairness.
object at that point?
Well, Your Honor, I was not the trial counsel.
Did trial counsel object?
There were no objections, and I'm going to tell you why. I'm speculating is we didn't want to highlight for the jury the issues that had come up. But also, it's only in looking back after the trial can you see where these errors came into place.
Thank you, counsel. You'll have an opportunity to address us further in rebuttal. Mr. Beauchesne?
Your Honor, thank you very much. I'm Richard Beauchesne. I'm Assistant DA for Oxford County. We are here this morning for a review of two decisions made by Justice Lopez below. The decision not to grant a motion to sever, and her decision regarding allowing Kathy Harvey Brown to testify. I think as the court is perhaps intuiting, the motion to sever, her denying that motion to sever, I think was sound, and frankly, I think it is grounded in case law of this court, going all the way back to Pierce in 2000, going up to LeMay, and also bringing in Olmo in 2014. I think that it's clear that the court, it's clear that joint is appropriate toward the multiple crimes that are of a same or similar character, or as Madam Chief Justice pointed out, that are connected or constitute part of a common scheme or plan. These two girls, crimes against these two girls, were most assuredly connected by a strong common scheme or plan. Obviously, they were same or similar results, but the common scheme was there. As the court pointed out, he is the father, the defendant was the father to one, stepfather to the other. It occurred over similar amounts of years, and there was actually overlap in some of those years. All the abuse occurred in the same home. All the abuse occurred in the same places within the same home. And more nefariously, more vilely, all of the abuse, each and every episode of this abuse was done in the same physical fashion. As I noted in my briefs, he would rub his fingers in a circular direction in and on the vagina of each child. Each child testified to this.
Mr. Beauchesne, I note that the green light is on, and you're spending a lot of time on that aspect about common scheme or plan, but why is a common scheme or plan relevant in this case? In other words, evidence, we use evidence that there's a common pattern, scheme, or plan. Generally, that's used to prove identity. Who did it? We know he did X, and this is how he did it, and that's a fingerprint that allows us to infer that he also did this other crime. That's not what's going on here. This isn't a question of who did it, right?
That's correct.
I mean, he denies, I assume he
Right.
did it, and, you know, the question is whether it happened or not. So there's no common scheme or plan that is relevant here, is there?
Well, Your Honor, I think there is. If you
What's
go-
it relevant to?
Well, if you go through the analysis on the possible points of prejudice that can inure to a defendant in a denial of a motion to sever. One is called evidentiary spillover, as indicated in the Olmo case. The idea that evidence in one trial would not have been admissible in the evidence of the other trial. However, it is admissible, and in Pierce and in LeMay and in Olmo, it sets out that the evidence in one incident was allowable.
Aren't those cases primarily involving uncharged incidents involving the same victim? It's really different when we're talking about two different alleged victims, isn't it? I mean, we went through a whole string of cases in State versus DeLong, surveying the case law. But looking at those, they involve the same victim and uncharged conduct. That's really different. I mean, when you start talking about common scheme, plan, intent, and all of those, the language, the standard language that everybody uses to get it out of 404B, they have to be relevant in the particular case. And the fact that there's a common scheme, if you start arguing common scheme in this case, how is that anything different than saying he did it to one, therefore he did it to the other? How is that any different from exactly what 404B is intended to prevent?
Well, Your Honor, that is the possible prejudice. But again, getting back to that.
Not just possible prejudice, that's what you can't use the evidence for.
I agree, Your Honor, but there are other appropriate uses. And the common scheme or plan, while it usually has one version or one understanding of it, in this particular instance, and I'd like to point to Pierce, which was not uncharged other conduct. In Pierce, there were 4 to 6 incidents of a sexual nature. Mr. Pierce always had himself identified by a friend as 19-year-old Ryan. This was in 4 of the 6 events. So we are talking about different victims in that case. And frankly, the court found a connection in Pierce because in each one of those incidents, there was a marker that went through all of them. And the court joined those counts because of that marker. And the same marker is here in this case. We have 2 separate victims.
I understand. What I'm trying to get from you, though, is how does that prove, what element does that prove? What does that prove to say that he did it the same way with one person as he did with another? What does that prove? It proves that if he did it once, he did it the other time.
But, Your Honor, it proves an MO.
Well, but why is the MO relevant? If you don't have a question of who did it or identity, right, why is the MO, it clearly is relevant when you have that. But why is it relevant when that's not the issue?
But the thing is, it is the issue if you're talking about the admissibility of the allegations of one child in the trial of the other, which would have happened had they been separated, but there was no need to separate it, because as the court pointed out in LeMay and pointed out in Pierce, there are safeguards that prevented this evidentiary spillover, or prevented the idea of a jury reaching the conclusion, well, he did it to one, he must have done it to the other.
I mean, to be honest, isn't that really kind of a myth that the jury doesn't use it when you have multiple? That's why you fight so hard to get it in and why defendants fight so hard to keep it out. The reality is that is what juries use it for. We pretend they don't, but that is what they use it for, isn't it?
Well, I'm a
I
cynic,
understand
might
there's
say-
jurisprudence
Yes,
that
I
says
understand, Your
differently.
Honor. A cynic might say so. But that's why judges have the power of the limiting instructions. And that's noted in that whole line of cases I talked about, how the limiting instruction of a judge, that the jurors have to consider each charge independently. They
And we have
can't
to
let-
assume that the jury will follow the court's instructions.
And I think that's a leap that we all have to take, Your Honor.
Can I
that the
ask you,
juries-
as I understand Mr. Feldman's arguments and his metaphors, he's saying that the motions were denied on certain assumptions that certain things could happen during the trial, but they didn't happen during the trial, and therefore I'm prejudiced. And my question to you is, when we look at the appropriateness of the action of on the pretrial motions, do we judge that in retrospect with what actually happened at the trial? Do you follow my question? In other words, that the state would have said to the judge, well, this is why you need to deny the motion, because this might happen at trial, but it doesn't happen at trial. Is that an appropriate perspective?
Your Honor, I don't think it is. I think we have to take it at that point in time when the ruling is made, and that ruling can be reviewed as it's being reviewed here. And the court has to determine whether or not based on the case law, whether or not based on the rules, and also to an extent what happened at trial as to whether that ruling was a sound one. It's correct to point out that the rulings, the decisions of the court regarding Ms. Harvey Brown were never objected to. And I think that is a point well taken also. But
In fact, of not objecting during the trial, you're saying it goes to the scope of what the witness testified to and whether it deviated from what the pretrial expectations were going to be.
well, I think it limits what the courts can really do about it. I mean, I think that if I'm reading the court's question right, the proper analysis of a ruling is when, at the time the ruling was made, was it based on her sound discretion? And I think that the case law has settled that. Certainly on the motion to sever, she was on solid ground in denying that motion.
Counsel, I could see circumstances where, a prosecutor acts in bad faith, makes misrepresentations, and on that basis, a court rules. That's certainly not the case here. And things happen. Decisions change as you approach trial and even in the middle of a trial. So my point, I guess, is I'm not sure I understand Mr. Feldman's argument completely. I don't think it is dispositive. I think you have to take, the trial judge has to take what is before her at that point and make a ruling based on the law. But I want to turn to the experts for a moment as well. There were no objections at trial to the experts. There was limited, if any, cross-examination. Were these experts qualified?
Your Honor, I believe Ms. Harvey Brown was properly qualified as an expert. As the rule points out, there are 5 areas in the conjunctive which are listed as ways in which an expert can be qualified.
Right. She meets the education component,
Yeah.
arguably. But she had no training in this area. She had conducted no research on her own. She had limited experience. She was familiar with the literature, but that's pretty much the extent of it.
Well, Your Honor, I guess I would argue with the claim that she had limited experience. This is a woman who participated in over 1,000 forensic interviews.
Well, yeah, we're talking about delayed disclosure, though. I think on the forensic interview, there's no question about her experience. But with respect to her qualifications on the delayed disclosure aspect, she had fairly limited experience there, didn't she?
Well, Your Honor, I think I would go back to her experience in the forensic interviews. I mean, these delayed disclosures, the venue for a lot of these delayed disclosures is within these forensic interviews. Certainly, a lot of time, the disclosures are made outside of these forensic interviews, but in the course of these forensic interviews, I think a practitioner develops an expertise regarding this particular area, as they so are often intertwined with the interview itself. It helps to explain the experiences she gained in these forensic interviews helps her to recognize and to explain the whole idea of a delayed
The purpose
disclosure.
of the testimony was to establish or to bolster in the jury's mind the state's explanation for why the daughter did not initially disclose, right?
Yes, Your Honor.
Should the witness have been allowed to present that testimony without talking to the daughter? In other words, that's my understanding, is the witness did not interview the daughter. And so the witness assumed that the daughter was in the category of children that she said the research indicates often delay disclosure
Yes.
of sexual abuse.
And Your Honor, it's absolutely correct that she did not interview either of the girls, and that was entirely correct and proper. And I'd go back to the court's decision in Preston, which established that the idea of a delayed or piecemeal disclosure was a generally accepted scientific principle. The doctor, there was a doctor who testified in that one, it was Dr. Jacobs. His testimony was proper because what he did, he testified to the observed phenomenon of delayed disclosures, and he testified that these are recognizable occurrences. He was asked in that case as to whether he had examined the girls, and he said no. And the court opined that that was absolutely direct and proper because he was not giving an opinion as to whether the children in that case, in fact, were making a delayed disclosure of actual sexual abuse. And that was also the case here. It was the objectivity, the lack of information about this case that allowed her to make a 10,000 view observation that delayed disclosures occur. When they occur, this is how they occur.
Is there a difference? I mean, obviously, there are academics, PhDs, who have research, and they've looked at, crunched the data and all the information, and may have arrived at the conclusion that delayed disclosure is typical. Here, in this instance, I think at best, the witness may have interviewed lots of victims who had delayed disclosure. So it's in her experience, what she hears. Is there distinction between an expert who's a PhD based upon research data and someone who simply sees it a lot?
Well, Your Honor, I think there's a difference, but frankly, I don't think it's a difference that matters in this case. I mean, as trial counsel below pointed out in exasperation, she doesn't have a PhD in anything, but I don't think that matters. Her knowledge was gained through experience, through practice. She said she was familiar with the research, stayed up on the research, and that, combined with her practical experience, qualified her as an expert.
Thank you, Mr. Beauchesne. And Mr. Feldman, you reserve some time for rebuttal. And with
Thank you.
rebuttal, the green light goes on right away.
I'm ready to go, but I just want to make a couple of quick points. We can talk all we want about 404B, but that's not in this case. We were told we're not dealing with 404B, so that whole analysis is out the window.
But I'd
If
like
you
to
think
take you
that's
back to
critical-
the expert question.
Could I just finish? If you think that's critical, it has to go back. In terms of the expert, one of the factors, Your Honor, is whether this person has tailored their conclusion to the facts of this case.
And Mr. Feldman, that's my point as well. There's no question that Ms. Harvey Brown was qualified as an expert in general to testify at least as to some things. Do you agree? I mean, she's a master's level LCSW with a lot of experience in forensic interviewing.
My belief is that she was qualified as an expert for forensic interviewing, and we have no quarrels with that.
And that's what I'm saying. So
Yes, ma'am.
in the abstract at least, she is.
Absolutely.
Okay. So now that leads us to the trial. And so at the trial, there were no objections to any of the questions. Not only that, you've not identified any particular question that was objectionable on appeal. So aren't we left with essentially waiver and unpreserved, it's more than unpreserved, it's essentially waived at this point?
No question, Your Honor, and I don't plan to dispute that. What I'd like to focus on is the delayed disclosure part of it, which I think is very crucial. I also think that there were things she said that were prejudicial. Because she was presented as someone who was an expert on forensic interviewing, she essentially said, every time someone is interviewed, it's because they have
We
been
work in the
abused.
question and answer format, and no question was objected to, nor have you identified a particular question that is objectionable.
I don't dispute what you're saying, Your Honor. I'm talking about the fundamental fairness of this case was that she told the jury more than once that anybody who had been forensically interviewed had in fact suffered abuse. She also told the jury, which I think is incorrect factually, but certainly beyond her kin, when it comes to delayed disclosure, children encode facts just like a computer does, and it's just a question of
So you use
accessing
the
them.
phrase fundamental fairness, so are you attempting to raise a due process, are you raising it as a due
Absolutely, Your
process
Honor.
issue?
This is a question, just like in State versus White, where we're not really concerned about the prosecutorial misconduct as to how we got here, but as this court noted, the discussion of prosecutorial error focuses on the impact of the prosecutor's behavior on the due process rights of the defendant, whether we had a fair trial. It appears to be that this court, rightly so, has determined that the idea that we need to drill down on is, was the trial fair fundamentally? We have at least 3 compounding fair factors of prejudice to this particular defendant.
But with no objection, you have to raise your argument to the level that the judge committed clear error. The judge should have stepped in and said, stop.
As the facts have unfolded, it's clear error to have joined those cases together and not severed them because we don't have 404B analysis, so we only have the 403 analysis, and the statements made by the expert witness were neither appropriate to her expertise. Thank you, Your Honor.
As is our usual practice, we will, of course, take this matter under advisement and issue a written decision in due course.